Let's bring in national trial attorney, big case Mike. He's Michael Jaafar. He knows this case quite well. The Commonwealth has to bring Proctor on. I mean, if they don't, that's an admission that, oh, we don't believe him either, right? I mean, they're sort of boxed in here. He's the lead detective.
You know, I was thinking about it. They should bring him in, but at the same time, in their mindset, they're thinking, well, if we bring him in, we cannot. You know, we'd be bringing him in for direct examination. He'd be a friendly witness, and so we can't really give him leading questions. We can't hammer him. Let the defense bring him in. They cannot give him leading questions. They have to ask him, you know, he's a friendly witness at that point. So it'll be direct examination, and we can come in on cross-examination and be a little bit more impactful. At the same time, bringing him in now would blunt. It's like when you're a kid, right? You get a bad report card. You call your dad before he gets home and you tell him about your bad report card. So when he's home, he's not angry anymore. He's just angry when he's like 18 miles away. So that's kind of the analogy.
To school you had back in the day.
Yeah.
It
was.
Yeah.
No cell phones. You call with desk phones. So for that reason, that would be the tension in the decision making.
Makes sense, perfect sense. Yeah, because you're right. There's such an advantage to cross, but I can't imagine them leaving him off, given the amount of time his name's come up. And do you get rid of, out of the gate, his comments to his buddies? I mean, he has this text thread, for people that don't remember this part of it. It's horrifying. He has a text thread with some buddies, and he says, hey, I got Karen Reed's cell phone. I looked through it for nudes, but I haven't found any yet. It's
so
not funny,
disorienting.
it's not anything, and he's the lead detective. It's like, oh, how's the jury going to take that?
It's so disorienting. Yeah. It falls right in line of the narrative of a cover, even though it has nothing to do with a cover-up, right? If this was in any other community other than Boston, it wouldn't really, it would still be, you know, distasteful and ugly, but it wouldn't fit into the narrative of that community, because there are some communities that fully believe if you blame their police department for a cover-up, they'll be offended. But in Boston, it's different. And so this just fits so, you know, squarely into the narrative of the defendant. So, I mean, it's very distasteful. He's going to be grossly embarrassed on direct examination, probably. So,
right, he'll have to look over at the families, the jury, and he'll have to say he regrets it, and it'll be over. So do you think they'll deal with that pretty? I mean, they have to deal with it before cross, obviously. You can't let Dad know about it, your report card. Yeah, you have to let him know. So we'll see how that goes. What about the defense case? Have they been able to, just through cross-examination, let's assume it's just Proctor and a couple others, and they're done on what? Have they been able to plant that seed of a conspiracy in the minds of the jury from what you've seen? I know you haven't watched the entire trial, none of us has, and the jury's seen everything and heard everything and felt everything.
No, I've seen a lot of the trial, and so for me, at the beginning of this trial, when somebody yells the word conspiracy, you put them at you put the bar very high. You tell them, okay, you're going to have to prove it to me. So if you're going to say that the conspiracy happened in front of a stadium audience, I'm not going to believe you. If you say it happened with just one person present, I'm more likely to believe you. But there were so many people there. This was already a very difficult thing for the defense to do. You know, the taillight evidence, I just feel like there's so much innuendo that the defense are relying on. Kudos to these guys. They're doing a phenomenal job in putting up a conspiracy defense, but it was difficult at the beginning. The picture's becoming a little bit more clear. The sobriety evidence, where she was basically drunk even the day after she was still legally intoxicated, after having many hours for the blood alcohol to metabolize. For me personally, that took me to the edge where I think she ran John O'Keefe over.
Intentionally?
Because not intentionally. She's got the 3 charges. I think they've already proven the vehicular manslaughter and the leaving the scene of an accident. In my opinion, I think they've proved it, because you just can't be that drunk and drive safely. I've been in these cases. I've seen the evidence. People run into walls. It's just being that drunk the day after means you were not ready to drive.
What about the guys getting rid of their cell phones the day before, they obviously got tipped off, you know, that they're going to have to turn their cell phones over or preserve them. This just doesn't ring true to a layperson. I would think a juror's going to really have a problem with that. And if you think, okay, I think maybe she hit him, but I'm not quite sure, and I'm not quite sure what those. That's reasonable doubt, isn't it? I mean, the question people come, you can't go anywhere without someone saying, hey, let's talk about Karen Reed. But the problem is everyone's got a different theory. I know what happened. I bet this happened. I bet this happened. Isn't that reasonable doubt, the fact that none of us know what happened?
It was explainable that he got rid of his phone because, as we saw from the testimony, his phone was compromised by another, not informant, by another suspect calling him. And so it is protocol for the police to get rid of their phones. He didn't get rid of it right away, but he replaced his phone within 2 months after any other detective would have disposed of their phone and changed it out, because their lives are different than our lives, right? So if they get a call from a suspect, they have to get rid of their phone. They have to swap it out. So there was an explanation. It just, if you come into this case and you believe
if it was just Higgins, all right, I'm with you. Multiple people get rid of their phones, same day-ish.
Yeah. I mean, he was also embarrassed. The testimony came out. He had something to hide. He was having flirtatious text messages with her while she was dating a fellow police officer. You know, that evidence is somewhat compelling, but at the end of the day, the defense have to, because she was at the scene of the crime, right? So she was there. There was a snowstorm. She was fighting with him. She was drunk. She's being charged with vehicular manslaughter. So she's there. So the defense are going to have to say that the jury has to believe that, no, he came into the party, he was murdered, and then he was disposed outside, and then they all threw away their cell phones.
Jurors don't need to believe that, though, do they? Do jurors need to believe that scenario to find her not guilty? Legally,
I think they do, because I think they do, because she's admitting that she was at the scene of the crime, but that she didn't run him over, that he went inside the house, right? So the jurors have to believe that either he went inside the party and there was something very sinister and nefarious that was conspired by a bunch of police officers, or it didn't, in which case nobody else could have ran him over.
So can the defense at the end of the day get up at closing with a straight face and say, listen, all right, we've got this theory about the dog bite that brought it. Maybe that happened, maybe it didn't. Maybe he was hit by a snowplow. Maybe he was this, maybe he was that. But they haven't proved that Karen Reed did this. Had they gone too hard on their theory to be able to backtrack and throw everything up against the wall in their clothes?
I think that they have been able to penetrate the top charge, which does require intent, not premeditation. But it does require intent, some sort of a criminal intent. So I think that they are fighting to get rid of that. I just don't see, like, the tail evidence and her being drunk. Really, no conspiracy is going to be able to negate those elements for the jury to find her guilty beyond a reasonable doubt, right? But if they can really get one or two jurors to believe that this man was either run over by a snowplow, or because they're not really hitting on that hard. What they're hitting on hard is, look at all this conspiracy. Why did you get rid of your phone? You guys all know what happened to him, and you're all hiding it. So I feel like it's an either all or nothing type of situation. I could see the jurors not believing anything about Karen Reed's defense are saying, but that this was a mistake. She accidentally ran him over. She was drunk, and so he's dead because of that. I could see them doing that. But even then, they get her on the top charge.
It's just a fascinating case. I don't know of another case where you really want to see what happened. Like, I mean, everyone has a theory. I mean, if they had video of this happening, everybody would click on it immediately. And I argue that's reasonable doubt. But you say she could go down. We'll see. They'll be back at it Monday morning, and Michael's going to be with us for the hour. All right, he said it was going to be an uphill climb from the very beginning, but good on them to try, because they honestly believe that he did murder his wife. Michael Jaafar, your thoughts on this verdict? There was no physical evidence really putting him there, and it was a tough one. What do you do now if you're the state, 8-4 on that, the manslaughter? The other charges are done. You get one shot at those, so they're not coming back with the same case. Your thoughts on whether or not, just listening to him, do you think they'll refile in this one?
I think they're going to refile, and I think they have to. They did an awesome job in the case, painting him out to be a villain, right? We all saw the non-admissible evidence in this case that the jury obviously could not see. We saw the fact that he was charged for stalking in Alabama. We saw that the same exact thing that they blamed him to do to Karen and to murder Karen, right? He's been basically accused of doing in Alabama with his second wife. Right? So this guy clearly is a villain. They painted him out to be a villain. 3 weeks after she filed the divorce, she winds up dead. And there was a screw in her tire, and it was down the street from her house, and the stories did not line up. But for the fact that there were no forensic evidence tying him to her body, he would have been convicted easily, right? It was a lack of forensic evidence tying him to the scene, to the actual body itself, is why he was not convicted, right? But other than that, you saw the jury was hung 8-4 in voluntary manslaughter, which in Tennessee does require you to intentionally kill somebody, right? So at least 8 jurors with no forensic evidence still found him to be guilty beyond a reasonable doubt. But a retrial of this case, if you're going to wait 10 years, 11 years to bring charges, that means you hate this person and you feel that justice demands that you bring the charges. So why wouldn't you recharge after a mistrial when you know you have the momentum on your side? You now know that any juror that comes in, unfortunately, will be tainted by all the non-admissible evidence, the text messages that were left out, the fact that they could not even talk about his stalking charge in Alabama. Why wouldn't you bring it? I mean, you bring it, you're not going to get a not guilty. You're not going to get 12 out of 12 jurors in the second trial saying he didn't do this. Right? There's reasonable doubt. So you either get another mistrial or you get a conviction, in which case you get some justice for the family of Karen. Which
makes July 2nd very important for both sides, because they'll argue bail. Right now it's revoked. If he's out on bail, go for it. They'll push kick the can down the road. But if he's not, then the state has him where they want him, at least while this is getting ready for retrial. Let's listen to the reaction from defense attorney Daniel Taylor. All right, they'll be back July 2nd again for that important bail hearing. Manslaughter would normally facilitate some sort of bail, but the state's going to bring in the Alabama stuff and all of that. Yes, the jury in this case couldn't hear it, but the judge sure can when deciding bail. Is that what you would expect, that it's the danger of society to society argument?
Yeah, he's going to get bail, but they're doing it right, because at the end of the day, Alabama is going to really, they're not going to hold somebody for months and months and months on a stalking charge, right? But the fact that he is up for a hearing for potentially another retrial, I feel like, they're going to get him out on bail. He's not going to be able to flee the country with 2 states chasing him down and hounding him the way they are. But at the end of the day, a stalking charge is serious because of the fact another person is saying, I have imminent fear and I'm in imminent danger if this person is left out, in society. But I feel like they'll leave it at $100,000 cash bond. I don't know if he can afford that, but they'll issue him bail.
Okay, we'll find out on the 2nd of July. And Michael Jaafar, 8 attorneys. At some point, it might not be them. It might be you. That's the problem.
Okay, you got me on that one. So I used to be a public defender. That's why I'm grinning, because people like her are not unfamiliar to any attorney who's ever been a public defender. They have mental health issues, right? To fire one lawyer, understandable but somewhat risky. To fire more than one, you have the problem, right? So, people like her are not unfamiliar to people like me and people who've done public defense work. They have mental health issues. This case is somewhat winnable, right? Because in Florida, with second-degree murder, they do have to prove that she had a depraved mind. That's one of the elements. And so depravity is a big, high bar. He did willingly go into the suitcase. I think what she did is still criminal, right? Somebody tells you, hey, take this gun and shoot me in the head. It doesn't mean you could do it and get away. Well, he told me to do it. But at the end of the day, it was zipping him in the suitcase. This case is eminently winnable, somewhat winnable. But she's doing everything she can to ruin it for herself, and I don't think she can recover. The jury's going to know she fired 8 lawyers, 7 lawyers, but she's got mental health issues, and you're seeing it.
Yeah, it seems that's what you said. All right, we need to switch gears because they are back from the lunch break in the sidebar. Michael Jaafar is with us there. That was a bomb, and the prosecution's like, well, you guys want to hear this one, Judge, and she let him say it.
That defense attorney has been doing a terrible job since the trial started this week. This is not the first time that she has done something, in my opinion, egregiously malpractice-y, okay? They should have taken a sidebar. She should have. How are you going to let somebody put a statement into open court and you don't have? The judge would have said yes to a sidebar, right? You could have told the prosecutor in front of the judge on a sidebar, you got to tell me what he's going to say so we can be prepared. The judge would tell him, I need to know. Right before the jury hears it, tell me the jury's still here. Just whisper it in my ear. Right. This is awful. This is not the first time that this defense attorney has been very, very, very subpar. And by the way, what does it have to do with whether or not you killed somebody, that you had a conversation with somebody theoretically? Could you get the death penalty by killing one person? But it's very prejudicial to hear that in open court. Because what do you say? Is that a confession? Is the prosecutor's point that the defendant confessed to murdering her and just wondering whether or not he'd be sentenced to death? Crazy.
Yeah. Well, the allegation here is that he was like, oh, yeah, but they only found out about this one.